How a child support case is established. Important to know, child support will continue until whichever of the following events happens first: a further order of the court, or the child dies, is emancipated, reaches age 18, or if a full-time school student residing with the custodial parent reaches age 19 or graduates from high school. There is an exception if the child has a disability. If a minor child has a physical or mental disability, then in some cases child support might be required beyond the age of 19. A parent, guardian, or the social service agency can establish and enforce a child support order. If a guardian establishes a case, then it must be opened against both parents. There are 4 ways to get a child support order established through the court. We'll discuss each of them. Number 1, stipulation and order. Number 2, social services through Dcss here in California. Number 3, local child support agency, Dcss. Number 4, filing your own court forms as self-represented or with the assistance of an attorney. Now, let's go over these 4 routes. I'll also provide a scenario to illustrate each approach. Number 1, stipulation and order. A stipulation and order is available when parents of minor children stipulate or agree to a reasonable amount of child support that the couple wants to establish and enforce as an order. When a stipulated agreement between the parents is reached, that stipulation must be filed with the court. Once a stipulation is processed through the court, it becomes an order. In some situations, couples use the assistance of an attorney to handle the negotiations, paperwork, and court process. But it's easy enough that parents will often decide between themselves what's best for their children, given their own financial situations. Then they prepare the paperwork themselves or hire a local paralegal to complete the forms and file them with the court. In my experience, this is the best way to establish a child support order. Although breakups are often difficult, parents who think rationally will usually choose this method to establish the child support order, as it is the least stressful for all concerned. Once the parents come to terms and they're ready to prepare the proper forms, how to go about completing the stipulation and order process depends on whether their relationship status is divorced or divorcing or unmarried. Here's a typical scenario for an unmarried parents. John and Mary are boyfriend-girlfriend. They're in a relationship and conceive a child. 9 months later, they have a beautiful baby girl. But soon after the birth of the child, they realize that they're not a good long-term fit for each other. John and Mary break up. John moves out of their shared home and into his own place. Mary remains in the home with their baby. Mary and John agree that Mary will be the primary parent for the child. They also agree on a co-parenting visitation schedule. Next, they address the issue of child support. John suggests that he pay support to Mary. The parents then negotiates a monthly child support amount for John to pay Mary. They compromise on an amount of child support that John will pay Mary. Of course, John isn't entirely happy about the amount, and neither is Mary. John thinks that amount is too high, and Mary thinks it's too low. However, they both understand the circumstances and agree the amount of child support is fair. Mary is unsure whether John will pay the agreed amount of child support each month, as he agreed to do since he has a history of reneging on his promises. John is really unsure if Mary will continue to accept the agreed amount of child support without squeezing him for more because she has a history of mismanaging her finances. Both parties feel unsure about each other complying with their agreement, but they don't want to go to court, so they do the next best thing: stipulation and court order. How they do it. John and Mary agree on a date to start the child support payment. They decide to get assistance from a local paralegal. Mary contacts and hires a local paralegal to help them establish a child support order through the court. The paralegal prepares the necessary forms to establish a stipulation and order. John and Mary sign them, and their stipulation and order package is submitted to the local family law court. The filed stipulation and order will legally bind both parties to the agreed amount of child support. Forms typically needed include summons and complaint, FL-210, Petition to establish parental relationship, FL-200, FL-105, and GC-120. Response to establish parental relationship, FL-220. Judgment along with stipulation and order, FL-130, FL-230, FL-235, FL-240, FL-250, FL-192, FL-190, FL-191, along with an addendum to judgment. Note, in some cases, you may be able to waive the response. Here's a typical scenario for a divorce or divorcing parents. After 10 years of marriage, Lisa and Joe have mutually decided to divorce because of irreconcilable differences. They have 2 children, a boy and a girl. Lisa petitions for a dissolution of the marriage. Joe moves out of the primary residence into an apartment nearby. Lisa and Joe agree to finalize their divorce without attorneys. They contact a paralegal to help with the paperwork. When it comes to the issue of child support, the parents compromise on a feasible amount, to be based on their co-parenting and visitation schedule. The parents have their paralegal prepare an uncontested judgment document, including the necessary child support forms according to their agreement. I believe that this is the best way to establish a child support order. Both parties are left feeling relieved afterwards. In addition, this provides a healthier way to deal with an uncomfortable situation such as a breakup or divorce. Forms needed typically include: for divorced or separated parents, if you already have an active case, you'll need file Stipulation and Order FL-350, along with necessary declarations and attachments. If you don't have an active case, you'll first need to file Summons FL-110, Dissolution of Marriage or Legal Separation FL-100. UCC-JEA, FL-105, GC-120, Stipulation and Order FL-350, along with necessary declarations and attachment. Number 2. Establish child support through social services. When a child support case is established through social services, it means there's a need for the state to recoup some or all of the money dispersed to the custodial parent through public assistance, PA, also known as cash aid for the child or children. The Department of Social Service Public Assistance Division will intervene after a parent caring for a child applies for public assistance in the form of cash aid. The recipient of this cash aid is required by law to disclose all known information about the other parent, or both parents if you're the guardian. This includes the parent's full name, physical description, address, phone number, email address, employer, social security number, and date of birth. Here in California, the Department of Social Services sends the information about the other parent over to the Department of Child Support Services, DCSS. DCSS uses the information provided by SSA to track down the other parent. Once DCSS locates the other parent, they will work to establish and enforce a child support order on behalf of the Department of Social Services, not the parent who is receiving cash aid. It's important to understand that in this situation, the payee will be public assistance, PA, not the parent who is receiving cash aid. The parent enrolled in the PA program has no say in the process. The actions taken against the other parent will happen with or without help from the parent receiving the aid for the child. In certain situations, if a recipient parent fails to provide the required information about the other parent, then benefits may be reduced or terminated. If you're a non-custodial parent and the Department of Social Services opens a case through DCSS, sometimes you'll receive a packet in the mail that typically includes summons, petition, letter from DCSS, response forms, blank income and expense form, child support calculation summary report. Other times, you will be served the packet at work or home. You must complete the packet according to the instructions and then return it to the designated location listed in the enclosed letter. If you're unable to complete the instructions in the packet and return it, or you're simply unclear about the process, then contact DCSS at 866-901-3212. Go to the Self-Help Center or visit the local office immediately. Don't go to the family law court for assistance unless the self-help center is located on those premises. In most cases, you must answer to the petition within a specified period of time, typically 30 days from the date the proof of service of the documents. If you fail to respond within the allotted time, Dcss may move forward with court proceedings, and you may be subject to a default judgment. Here's a typical scenario. Chelsea and Terrell have 2 children together. They're not married, but they've lived together for 3 years while raising their 2 children, ages 1 and 3. One day, Terrell discovers that Chelsea has another boyfriend on the side. He ends their relationship and tells her to leave their home. Chelsea leaves the children with Terrell and moves in with her new boyfriend. Terrell keeps the children. They arrange a visitation schedule, and Chelsea agrees to take the kids every other weekend from Friday to Sunday. Sometime later, Terrell starts having financial difficulties and can't keep up with his bills. The children need more. He goes to the Department of Social Services local office. He explains his financial situation and seeks help for his kids through public assistance. The social worker tells Terrell that the children qualify for cash aid, but he'll need to complete some additional forms. One form asks for information about the other parent, Chelsea in this example. Terrell provides all the necessary information. The social worker opens a case for public assistance, cash aid. Soon afterward, Terrell starts to receive cash aid, public assistance, for the children. One day, someone rings Chelsea's doorbell. Opening the door, she's greeted by a guy with an envelope in his hand. He asks her name. When she replies, he hands her the envelope, telling her that she has been served with a legal notice, then walks away. Opening the envelope, Chelsea learns that a summons has been filed against her for child support. Chelsea reviews the documents, then calls Terrell. When she asks Terrell why he put her on child support, Terrell explains that he didn't do it. He further explains that he only gets cash aid for the kids through the Department of Social Services Public Assistance Program. When Chelsea calls the Department of Child Support Services, Dcss, to see why she was served with the paperwork, she speaks to a customer service representative, CSR, who takes a message. The CSR sends Chelsea's message to her assigned child support officer. The child support officer contacts Chelsea. After confirming her credentials, the child support officer explains that Terrell has been receiving public assistance in the form of cash aid through the Department of Social Services. The child support officer further explains to Chelsea that because she is the non-custodial parent, NCP, and Terrell receives cash aid for the 2 children, the state social service agency recovers a full 100% reimbursement from the NCP. If that is not possible, then they will seek to obtain the maximum amount of the money possible that has been issued to the parent caring for the children from the NCP. To assist in recovering that money from the non-custodial parent, the Department of Social Services seeks help from its related agency, the Department of Child Support Services, DCSS. The child support officer further explains to Chelsea that included in the packet of forms is an answer-response form as well as an income and expense form. Chelsea is asked to complete the forms and return them as soon as possible. She is also told that her failure to provide the requested information might result in a default judgment against her. Chelsea completes the necessary forms, then submits them within the required time period. The child support officer receives Chelsea's information. She uses that information, coupled with information from social services sources, to help calculate the correct amount of child support, using the Child Support Guideline Calculator. Next, the child support officer contacts Chelsea to inform her about the guideline amount of child support to be paid. The child support officer, CSO, also explains that Chelsea has 2 options. If she agrees with the calculated guideline amount, she can sign the necessary forms for a stipulation and order. If she disagrees, she can go to court and have the case heard before the court, who will hear the case and determine the child support amount. In this example, Chelsea decides to agree to the child support guideline amount already set by the child support officer from DCSS. A stipulation and order is signed, and Chelsea starts making payments. Note: most times the court will assign a facilitator to the local child support agency. The facilitator's duties include overseeing and signing off on stipulations and orders. It's also important to understand that Dcss will not allow the parent to stipulate to anything less than the guideline amount if PA cash aid is involved. Number 3. Establish child support through the Department of Child Support Services, Dcss. When a case is established through the Department of Child Support Services, Dcss, it's because one of the parents decides to seek the assistance of Dcss to establish and enforce a child support order. The parent that wants to pay child support, called the payer, or the parent that wants to receive child support, known as the payee, both have the right to utilize the services of Dcss. Usually, Dcss is the first place where a parent or guardian goes when they seek to open a child support case. The Dcss application itself can be time-consuming, but once completed, the rest of the process is a piece of cake. Routinely, it takes about 30 days to open a Dcss case. Once a case is open, Dcss will work as the middleman in establishing and enforcing a child support order. Once a Dcss case is open, they will have the parent that is opening the case complete an income and expense form designated FL-150. This form will give Dcss information pertaining to your income, proposed alleged income of the other parent, and the percentage of time the child is in your care and in the care of the other parent. Dcss will use that information along with other information to complete court forms necessary to establish paternity of the child, if needed, and a judgment for child support. They will then file the forms with the court. The court will open a paternity case and assign a court case number. When Dcss receives the forms from the court, they prepare a packet to send to the other parent. The packet includes the forms that were filed with the court, a blank answer response forms, a blank income and expense forms FL-150, and a letter from Dcss. The letter informs and instructs the parent that is receiving the packet that a child support order has been opened and the ways he or she can respond. In my experience, it is always better to respond to Dcss. Failure to respond may lead to unintended consequences that may cause you financially. Sometimes Dcss will have incorrect financial information because they received misinformation about your income that was given to them by the parent that opened the case. Other times, the parent that opened the case may claim to have the child more time than he or she actually does have them. Regardless of the reason, even if all the information is actually correct, you should always respond to the Dcss about your case. Before you respond, though, I have a few suggestions on what you should do within the first 10 days of receipt of the forms. First, you must open the packet and review all the information. Look at the Form FL-600, Summons and Complaint, page 1 of 8. Check to see if the minor child's name listed there is your child. Assuming the child belongs to you, move on to page 2 of 8. Keeping in mind the information about you on this page is what Dcss has received from the other parent. You will often find the information is correct. Review all that information on this page carefully to confirm it is correct or not. If your actual information is different from what is outlined on the page, make note of it. Then move on to FL-630, Judgment Regarding Parental Obligations, for review. After you review the FL-600 and FL-630, grab the Income and Expense blank from FL-150. I suggest you complete the form, not so that you can turn it in, but so that you can use it as a draft. The FL-150 you draft should include your factual information supported by proof of income, billing, statement, etc. Once complete, move on to the blank FL-610. I suggest you complete this form. Remember, it's the same thing as the FL-150. Use it as a draft. After you have reviewed all the information and drafted the FL-150 and FL-610, contact Dcss. Call the toll-free line. The phone number should be located on the letter you received in the packet. Usually, you may first have to speak with a child support representative, CSR, who will take a message from you and pass it to your assigned child support caseworker. Other times, the caseworker's contact number will be located on the letter. Nevertheless, you will eventually speak to a caseworker. Note, when it comes to Dcss, there are 3 departments to handle a case. Your case will fall into one of these departments at some point while they are involved. The departments are establishment, modifications, and enforcement. You can refer to them as departments, teams, or committees. It really doesn't matter. With that being said, the caseworker that handles your case will be assigned based on the department and the caseload of caseworkers in those departments. Also, it is likely to have your case transferred to a different caseworker in the same department. You will speak with a caseworker on the establishment team. The role of this caseworker is to establish a child support order either by stipulation in order or through court order. The caseworker will let you know why you received the packet. At this point, do more listening than talking. Gauge the caseworker. After you speak with the caseworker, decide if you feel comfortable with the process, or if you should seek the assistance of a paralegal or an attorney. Whatever you decide, provide your answer to the court and Dcss within 30 days in most cases. If you decide not to seek a paralegal or attorney for assistance, Dcss can provide the support you need so that you may complete all required forms. Also, keep in mind that if you file a response or answer with the court, you can still settle without going to a court hearing. When Dcss establishes the child support order, you're able to avoid court in some cases. This is because Dcss has a team devoted to assisting parents with obtaining a stipulation and order, instead of going to court. A stipulation and order, as it relates to child support, is when parents come to an agreement on the amount of child support the payer will pay the payee. The agreement is reached between payer and payee without any third-party influence. A stipulation and order can only be done if both parents or a guardian agree to the terms and the amount of child support without being forced. The caseworker acts as a mediator of sorts in helping the parties discuss their options, as well as gathering information and calculating the support amount using the Dcss guideline calculator. The caseworker will communicate with you and the other parent to determine an amount based on the Dcss guideline calculator. In some cases, parties can agree to stipulate to a different amount outside the guideline amount that is either above or below that guideline amount. Dcss will handle all the paperwork and legwork necessary to ensure a child support order is established and enforced. However, if the parties fail to reach an agreement, then the case will go to court and be heard by a judge or commissioner. The Dcss attorney does not represent either party. If the case is heard in court, it's very important to understand that a Dcss attorney doesn't represent either party. Contrary to what most people believe, there is no attorney-client relationship between the recipients of its services and the Dcss itself. As an agency of state government, the Dcss represents the public interest in establishing, modifying, and enforcing child support obligations pursuant to the law. You should keep in mind that the Dcss attorney is not representing you on the case. Here's a typical scenario. Mike and Sally have been separated for more than a year. They have one child together, a daughter now 3 years old. The parents don't have a custody order currently. Sally is the custodial parent since the child lives with her full-time. Mike has visitation time with their daughter. He spends time with her whenever he has a day off work. Occasionally, Mike gives Sally money for the child's needs. This habit irritates Sally because she works at a minimum wage job and also does freelance hairstyling on the side, just to keep a roof over their heads. Sally struggles to make ends meet each month because of the cost of childcare, food, and the expense of maintaining a 2-bedroom apartment in Southern California. She routinely asks Mike for money to help with expenses for their child, but Mike always cries broke. And on those rare occasions when he dishes out a few dollars for his child, he acts as though he's a father of the year. One day, Sally called Mike to ask for money to buy shoes for the child. She tells him the shoes will cost $90. He flies off the handle. Mike complains about how expensive the shoes are. He tells Sally that he believes she intends to use part of the money for herself, not shoes for the child. When Mike insists that she get a receipt confirming the purchase, she becomes very irritated. The next day, Sally goes online to Google child support. She finds a state website for child support and opens a case through the online platform. A few days after Sally generates the case, a worker from Dcss contacts her and requests additional information. About 90 days after Sally opens the case, Mike is served a summons packet from Dcss. The packet includes a summons, an income and expense form, a response form, and information about Dcss, including its toll-free phone number, 866-901-3212. Mike calls Dcss. Within a couple of days, the caseworker contacts him and explains the process, including the DCSS's role in assisting with the establishment and enforcement of child support. The caseworker tells Mike that he has an opportunity to settle the child support issue by means of a stipulation and order without going to court. What happens next? DCSS requires both parties to provide an income and expense form and a visitation calendar or an enforced child visitation order. The caseworker will use the visitation schedule to calculate a percentage of time each party spends with the child. The agency will also ask for paycheck stubs if you're a W-2 employee, or any form of income verification such as a 1099. Other expenses to be verified include child care expenses, extracurricular activities, and children's out-of-pocket medical costs and hardships, if any. The caseworker will enter both parties' information into an online spreadsheet called the Child Support Guideline Calculator, CSGS. It uses that information to calculate a child support amount range, usually to be paid by the non-custodial parent to the custodial party. Note, there are some situations when the custodial party pays child support to the non-custodial parent. For example, the guideline calculator will calculate a child support range from the lowest acceptable amount to the highest amount a party will be able to receive, which ranges from $500 to $586. The caseworker will present the child support range amount to the parents. The parents will discuss their financial situation in conference in hopes of obtaining an agreed amount of child support to pay. After parties agree, the caseworker will prepare a stipulation and order for both parents to sign. The same as in the example scenario with Sally and Mike, a stipulation and order are legally binding on both parties once it has been filed. During the process, the court will review, approve, then sign the stipulation, making it an enforceable order. Typically, after the stipulation and order is approved and signed by the court will mail a copy of its order to each party to keep for their records. Overall, here's my suggestion. Unless the proposed child support amount is truly in your favor, I believe it's best to exercise your right to go to court. A caseworker might forget to input pertinent information related to the case, such as hardships or the appropriate parenting percentages. It may lack the proper quality assurance by the court-appointed facilitator. When in doubt, seek the assistance of higher authority. You might convince the court to consider information overlooked or dismissed by the caseworker. In addition, prior to appearing before the court, you'll meet with a DCSS attorney to discuss your case. You may be able to have the attorney take a second look at your case. That attorney will run the calculation again in hopes of coming to an agreement. If you still disagree, then in my experience, it's best to take it to court. Number 4. File your own court forms as self-represented, pro per, or with help from a paralegal or LDA. You can establish a child support order yourself by acting on your own behalf, which is called pro per from the old legal phrase in propria persona. When a child support order is established in pro per, it means that one of the parents or minor child is seeking an order for child support from the court. If you can't afford an attorney and you refuse to go through the DCSS, the next best way for a parent to go through this process with the court is with the assistance of a paralegal or legal document assistant, LDA. Note, a paralegal or LDA cannot give you any legal advice. However, they can prepare legal forms and declarations. A good paralegal or LDA will be familiar with court forms and procedures. If you have any trouble locating a paralegal or LDA in your area, contact me through email. Either parent has the right to establish a child support order in pro per. You can even open a child support case on yourself. In my opinion, if you are the non-custodial parent, the best way to establish a child support case when you were never married and you don't have an open child custody and visitation order is to petition to establish parental rights first through the court. Then you can file a request for the order for legal and physical custody, visitation, and child support. By filing a request for order, you will receive a court date for a court hearing. You can file the petition and request for orders at the same time. If you are a non-custodial parent and you have questions for why you should couple the custody and visitation request for order with child support, ask an attorney or an LDA in your area. If you are not able to find someone in your area, contact me through email. If you have a custody and visitation order going through a divorce, divorced, or you are legally separated, you can request an order for child support by filing a request for order with your existing case number. A parent will often file to establish a child support order because there has been a failure in child cost sharing, broken verbal promises of financial support for the child, or there are problems with routinely receiving a steady fixed amount of child support. Other times it is due to a person outright wanting to control someone or out of spite and anger. Here's a typical scenario. Jax met Lily through mutual friends. They had a one-night stand, but neither parent really knew the other prior to Lily becoming pregnant. Now they have a healthy 4-month-old daughter. Jax is single and has 2 other children from prior relationships. Both mothers of his kids have established child support orders. Those child support orders are being enforced by means of wage assignment through Jax's employer. For Lily, this is her first child. Throughout the first 4 months of their baby's life, Jax was there regularly. When Lily told Jax that she needed money to move into a new home with more space for the child, he helped her. Jax continues to visit his daughter regularly, and he gives money weekly for her support. The amount of money he gives is always the same. One day, Lily asks Jax for some money to get her nails done and also buy diapers for the baby. He says no. Jax then goes to the store and he returns with some diapers. He gives Lily the diapers and tells her that he will not be paying for her nails to get done. He also says that she already receives enough money each week to buy what their child needs. Lily gets upset. She tells Jax that as a mother of his child, she's entitled to receive money from him. Lily tells Jax that she knows he makes lots of money, and if he doesn't give her money directly, then she'll get it through the Dcss. When Jax hears her say this, he becomes disturbed about the situation. He kisses the baby and leaves the house. The following day, Jax calls off work and he goes to the family law court self-help center. He speaks to an assistant who gives him help. He gathers the proper forms to establish parental rights and request a court order. Jax completes the forms needed to establish a custody and visitation order, along with forms to establish a child support order. Prior to Jax taking the forms to the court, he contacts a local LDA to review the forms. Together, they go over all the forms. The LDA highlights a few errors on the forms that need corrections before submittal into court. The necessary corrections to the forms are made. Jax immediately files the forms with the court himself. He hires a process server to serve Lily. The process server served Lily and files a proof of service with the court, then returns a stamped proof of service copy back to Jax. Prior to going to court, the parents meet with a mediator. With the mediator's help, they arrange for joint custody and a co-parenting visitation schedule. On the day of their court hearing, the court asks each party if they have agreed on the custody and visitation agreements. The parents confirm their agreement, and the court reviews each of their income and expense forms FL-150 with support declarations. The court enters the necessary information into the online child support guideline calculator. Then the court issues an amount based on the guideline. The amount Jax must pay is made an order. Jax is happy about the child support amount because it is much less than what he was paying her directly. I've now explained all the ways in which child support can be established. That concludes Chapter 1 from the book Child Support Orders Matter, written by Xavier M. Marshall Sr. We hope that you found the information provided helpful. To receive more helpful information, subscribe to this channel. If you have any questions or comments, you can email us at maddadfam@gmail.com. That's maddadfam@gmail.com. To send a monetary contribution, you can Cash App us at $MakeItHappen007. That's $MakeItHappin007. Venmo at yourservice951. That's ATYOURSERVICE951. Or send a check or money order to 4192 Brockton Avenue, Suite 203, Riverside, California 92501.